So for the first time ever, we're going to have a guest back. We've had some amazing guests so far as we've started this journey down the Benefits Alliance voice, Carolyne. And we'd love to have all our guests back at some point. However, we've had a lot of questions since we launched that first one with our guest today, Darcy Michaud. So thanks again for coming back, Darcy. Really appreciate you being here. And we've had a lot of questions, Carolyne, just to kick it off. So why don't we get it going?
We sure have. Yeah. So today we're going to dive into probably the second hottest topic or questions that you get from employers. What is that, Darcy? Tell us what topic we're on for today.
It's always terminations and layoffs.
Yes. Okay. All right. So yeah, you know what? I can imagine. What is the difference? Let's talk through that. What's the difference between termination and layoff?
It's actually a great question because it gets asked way more than you know without someone ever being asked. It's just a general misunderstanding. So we'll get a lot of people, and whenever we have a question come in through our triage at HR Covered, whenever there's a question, we want to lay somebody off or we want to terminate somebody off. Can we get a template? We automatically put them through to our advisors so they understand the difference between the two. So a layoff is temporary. So you hear the term permanent layoff, and it's become a very accepted term across Canada. Every jurisdiction, even Service Canada uses it or allows it to be used in their, the ROEs. But in fact, there's no such thing as a permanent layoff. There, you could call a permanent layoff a termination once the temporary layoff is done. But when you're laying someone off, you're doing so with at least the intention of wanting to bring them back, or you have no intention of bringing them back, but it's temporary. And at the end of 17 weeks or 13 weeks, depending on the jurisdiction, they're terminated. When you terminate somebody, they're gone. You have no more obligations to them. You pay them what you're owed, or if it's a for-cause termination, you don't pay them anything, but they're gone. So when you have a layoff, there's still obligations to the employer. If you were to go out and hire another employee, they could potentially claim constructive dismissal. They're not on your payroll, but you still have obligations. So it's a big, we have, especially with our American employers, they'll say we're going to permanently lay off this employee, or they refer to a termination as a layoff in the States. That could get you in a lot of trouble and cost you a lot of money. So it's really important. One's temporary, one's permanent.
Well, while I'm temporarily laying off an employee, as an example, do I have to provide them benefits?
When you're laying off an employee, no. So when you're temporarily laying off an employee, you do not have to provide benefits. If you do, it could extend the amount of time in most jurisdictions in which they're allowed to be laid off. So in Ontario, for example, you can be laid off for 17 weeks. With that, you don't have to provide benefits. Then at the end of 17 weeks, they're done. So if you provide benefits, that can be a longer period of time, 13 to 17 weeks you can be laid off for. If you provide benefits, that could be up until half a year. So it's really important. You don't have to provide benefits, but there is an absolute, like if you believe that you don't want to lose an employee, but you believe your business would be in a better place to bring people back in 3 months' time or 4 months' time, by simply providing benefits, it extends that duration for which the auto termination happens, and then you would owe termination obligations.
Especially in a world where, finding talent is a struggle these days. But similar to our last episode, I can imagine you can't pick and choose, right? Would you have to be consistent, or can you? Because if you've got that rock star employee and you literally are doing a layoff because you have to as a business, versus someone that's maybe not your rock star, like, what can we do and what can't we do here, Darcy?
Ironically, you can pick and choose.
You can.
Yes.
So I'm laying off two people and I can pick and choose who I bring back and not bring back?
Yes. Now, here's the thing, and because this is an important caveat, because this is the question we get all the time. They're like, okay, we have this employee who's been here for 10 years. Not a big fan. We've kept him here. We've never done anything, so we can't get rid of him without costing us a lot of money. And then we have this employee who's been here for a year, and they're a rock star. We have to lay one of them off. Or we lay them both off, and then we have to make a choice on who we're going to bring back. If you decide to let that person that's only been there at the end of the layoff period just stay off and say, okay, now you're terminated because the layoff period's over, that person that's been there for 1 year might cost you a couple of weeks, might cost you a month or two, what have you, to give that person, pay them out their termination obligations. At the end of the 10 years, that 10-year employee, when you decide you were not going to bring them back, you don't have to bring it. You can make that choice. It's just going to cost you a heck of a lot more, because that employee that's been there for 10 years costs anywhere from 6 months to 12 months or more. So it's super important that you recognize that, yes, you can pick and choose. Now, keep this in mind. This is all provided you're not in a unionized environment. If you're in a unionized environment, seniority kind of rules. But in a non-unionized environment, you can pick and choose. But if you pick the more senior employee to be the one that is laid off or not brought back, either or, it's going to cost you a heck of a lot more at the end of it.
I have a follow-up question just to be absolutely clear. On the topic of extension of benefits, you said you can choose whether to offer benefits during the layoff period or not. Is that a spot where you have to be consistent, or can you pick and choose there as well?
That is a super excellent point. There's nothing that specifically says that you have to, but to your point, I would absolutely caution any employer if you said, I'm going to give one person benefits and not the other. It just launches into a whole bunch of things. Forget the company culture thing, forget the equity of it all. You can get yourself into a discrimination claim. You can get yourself into a human rights claim based on fairness. There could be anything about that employee that you did not offer benefits to when you offered it to the other that could put you in a really liable spot. And a lot of benefit companies, and correct me if I'm wrong, a lot of benefit companies don't necessarily allow you to choose which person you're going to provide benefits. It's like you have to provide them to one or all. So, that's a consideration as well. But that is a great question. So,
yeah, I agree. I agree with that. It's continuity for the employer. They have to have continuity and consistency from a policy standpoint.
Yes.
And let's face it, from a cost standpoint, for the 6 months, let's say, of benefits, continuing that in both scenarios is, for the sake of consistency and avoiding unintended consequences, it's probably worth it.
Well, and you're talking that benefits usually represent 4 to 5% of an employee's gross income. So it's not a significant portion to avoid a potential longer litigation or situation.
The amount of money it's going to cost you to extend benefits, even if it's after termination in those provinces or jurisdictions where that's a question mark, relative to the amount of money it could cost you, it's minute. It's a fraction. So, there's certain times when no one likes to spend money when they don't have to, but there's certain times when spending money is actually a wise choice. It's like hedging your bet, if you will.
We've talked about some of the most common questions you get from clients. What are, as a benefit advisor, because you work with a lot of benefit advisor firms too. So I guess I got two questions. First one to fire at you would be, what are the most common questions that you would get from benefit advisors? Maybe their clients come to them with a question and they go, oh, that's a great question. I better reach out to an expert. What would be kind of common questions?
The most common question we get from benefit providers is at termination, do we have to extend benefits past the actual termination date? And it's a loaded question, and we talked about it prior to the podcast. In some jurisdictions, you have to provide, it says it specifically in the legislation, namely Northwest Territories and Ontario, the statutory minimum, which is the amount of time the ESA, the Employment Standards Act, begging your pardon, says that you must provide termination notice or pay in lieu of notice, even if you provide the pay in lieu of notice, so they're no longer in the workplace. If it was 4 weeks, for example, you have to extend benefits for those 4 weeks. That's a non-starter.
All benefits, all life, long-term disability, health.
All of it. Now, you can, in this circumstance, because there are some benefit companies that will not, and I actually agree with this personally, and I agree with it from an employer point of view as well, that STD, LTD, and life, I'm very hesitant to extend those benefits through any period of time. You can provide the cash equivalent of that.
Second point then on that, let's continue this for a second, would be severance. So if an employer wants to severance an employee longer than Employment Standards Act, talk to us about that. Do you usually see benefits extended for that period of time too?
I like to use that as a negotiation tool. So what I mean by that is that as scary as unpleasant as they are, doesn't matter how long you do this. I've done thousands of terminations. They're never easy and they're never pleasant. But when you really break it down, they're not that complicated. It really all comes down to a negotiation. You put your offer on the table if you're going to be providing monies over and top of statutory pay. You put your offer on the table. They either take it or they either come back with, whether it's lawyered up or not, they come back with their own offer. I like to, if I'm, say, for example, someone is entitled to 8 weeks termination pay, but I'm going to offer them a half a year pay. I like to say we will extend your benefits for those 8 weeks. They come back and ask for 30 weeks or something other. Tell you what, we'll give you 28 weeks, but we'll also extend your benefits for that entire duration of your common law period, which is the severance. And then the most important part is then you have to go to the benefit provider and say, can we do this? That's not something as an employer you have the right to do, because most benefit providers have language in their contract that says the employee has to be actively employed to be eligible for benefits. So you need to go, it's really important. This can get you in a lot of hot water and cost you a ton of money, because if something happens, if you just assume that the benefits are going to be provided, and something happens, especially if it's an STD, LTD, life insurance claim, something happens during that period of time and you never asked for permission from the benefit provider to extend those benefits, they're completely within their right to point at the contract and say, we're not paying that. And there's case law, just, we talked about that earlier. There's case law where someone did actually have life insurance extended on the assumption that the benefit provider would do that. Someone in their family actually passed away, and the company had to eat the entire amount of what would have been the allotment of life insurance.
I think this is so critical. We talk about this in Benefits Alliance with our advisors, the importance of just companies coming to your benefit advisor first, let them know we want to extend, like, as you said, for 30 weeks, for benefits. Because you're right. And the big one too, that usually does not get extended now that we see more than ever is travel insurance as well. So you might have to keep your whole health and drug and dental plan, but not your travel insurance. Nobody wants that. Oh, that they turn back and the employer is going to have to cut a check if there's a significant claim, as you said. Great points.
Yeah, no, that's a really good point. And I think also, I think a point needs to be made is it's really important, like myself in an HR capacity and in the benefit broker capacity, it's really important for those two parties to work together for situations like this. There's a really easy synergy there between the two entities. And when they work together, especially around terminations and medical leaves, which we discussed last time, there's a lot that we can do together to make, that employee whole and make sure everyone's taking care of their liabilities mitigated.
Yeah. So big lesson number one, I think a lot of employers think that, okay, I have the power to change my employee benefits contract. I can do what I want. They think they can, but definitely check with the benefits advisor and the insurance carrier first, and then extend that offer. Otherwise, you could, in that scenario, if someone passed away, you're paying $25,000 or $100,000 life claim in the company. That's a huge cost.
For 99% of the time, the insurers will extend benefits to what you request, right? As long as it's nothing that's outrageous, like year, 2 years, 3 years. But yeah, watch that, but we will only extend these benefits in particular. So it's critical.
It's important.
Let's talk about the right way to terminate someone as well, right? So, we talked about the rock stars, but let's face it, there will be times where it's just not a fit, right?
Yeah.
And so, there's lots of scenarios. I think everyone knows, you need to have your written reprimands and different official records of the conduct that is not lining up with the job. So we've been told we may not be able to do that with cause. Can we offer less severance given all the issues? Talk to us about that type of scenario.
Yeah. And I think now they say that there's no longer the terminology termination with cause no longer exists. They say termination without pay, which is the same thing. I quibble with that, people trying to change the terminology, but it's important to note. I always say it's like terminations are not horseshoes or grenades. You either have cause or you don't. So there's no, we almost have cause, so that should cost us less when we terminate the person, right? No, you either have it or you don't. When you actually say we're terminating you without cause, it means you have nothing. You can't walk up in front of an arbitrator. You can't walk up in front of a judge or a mediator and say, we have all of this and terminate for cause. Well, we don't have as much as we needed. Well, then you terminate without cause. The courts don't care. The courts don't care if you go bankrupt. They don't care if you had to lay off people and then terminate them due to COVID. They don't care if it's the worst employer in the world and you just didn't document it properly. They're going to pay that person what they're entitled to by, the rules set out in case law about the precedent about what are the factors that establishes the common law amount over and above the ESA amount or ESC amount. And they're going to say, this is what you owe. So if you don't have cause, even though it is a really bad employee, it's going to cost you the same as a perfect employee that you unfortunately have to let go. There's no way around it.
So how do you make sure you do the definition of cause the right way? What does that look like?
Yeah. So there's two things. Like there's two bars. And this is for the employers in Ontario, that are watching this, my condolences, because it is a different world. In every other jurisdiction, simply getting cause, which is basically in layperson's terms, it's basically saying the arrangement is, or the relationship is damaged beyond reproach. So you just can't work together. And there's reasons that happens. It either happens because of a single egregious incident. So, sexual harassment or workplace violence might be on theft, breach of trust, things like that. That might be a single incident that would necessitate a termination with cause. Or it could be a culmination of incidents which turn out to be egregious, which is progressive discipline. See, a proper progressive discipline path, and we had this conversation with the client yesterday, who unfortunately had to withdraw. They were going to terminate somebody with cause. And I looked at their paperwork and I said, you don't have it. You need a first counseling letter or verbal, that a lot of people refer to it, which has to be non-punitive in its nexus. You're making them aware that there's a problem. You need to fix it. We're going to support you. And that clearly has to say that in the letter. Well, this is what we're prepared to do to support you. It has to be non-punitive. Then if it happens again, then you move into the formal discipline, the first written, second written. I like that second written. The third, which is typically a suspension with or without pay, and that will depend on what you put on your policy, and then a termination. And every single letter has to have specific things in it. For example, every letter has to be very specific about what the next step is going to be if they do something like that or something similar to that again. So on the termination first written warning, it needs to say, should you do this again, you will receive further discipline up to and including termination. On the last written warning, or suspension, if you will, it's just specifically saying in the letter, if you do this again, you will be terminated. It's so important that when a court looks at it, they're looking at it to see that the consequence was clear to the employee when they received that letter. In Ontario, there's a further burden. You have to reach the bar of willful misconduct, which means everything that they did was proven to be intentional or deliberate. That's difficult.
That's a lot to take in. So I am thinking about our listeners here. There's a lot of employers out there that either have HR departments or don't have HR departments. So a lot to take in. So number one is what I'm hearing is before you write the letter, you should consult with an HR expert. And also, what about those that are companies with HR departments? Do you have people coming to you for that kind of second opinion? You're like, you want to make sure you do it right. If you haven't done it before, do you see that a lot of that happening?
Yeah. Ironically enough, we have thousands of clients now across Canada, and more than half of our clients actually have HR departments or HR people. And for me, I'm a little bit biased. I enjoy working with other HR people. I consider them, regardless of whether they've been doing it for 1 year or 30 years, I consider them to be my colleague. Sometimes I get the opportunity to mentor. Sometimes I get the opportunity, like the example we were talking about, I have a large municipality where there's been a director of HR there who's been there for over 25 years and is super great at her job. But she'll call me up and say, Darcy, this is what I'm thinking about doing, or this is what I'm thinking about offering. What do you think? She literally uses me as a second opinion, a second voice. And she said it to me more than a few times. She goes, you doing this for as long as I have, getting to call you and saving myself $500 on that call to the lawyer is a real win for me. And we have a great relationship. And I have a lot of great relationships with my clients that have HR departments or HR professionals, even senior. We're not meant to replace anybody. That's never been our model. We're just meant to complement and provide that expertise.
Great point as well about, when should a company call you versus calling their lawyer? Or do you feel that you can get, companies say 50% of the way there before they involve a lawyer, or 75%? Or what do you find in your experience that you can help organizations at that first step?
Yeah, it's a really good question, because I think it speaks to the integrity of our service and its integrity of the kind of HR we provide. And what I mean by that is there's a line. And if you've been doing HR for a while, you know where that line is, where you say, okay, like if someone's calling me up and saying, we want to terminate this person, this is how long they've been here, this is how old they are, all the factors we need to determine a termination package. We can answer that for them and we can give them a ballpark. If it gets to the point where, it's an executive termination, or there's like shares or stocks that are involved in the termination, human rights get involved, or it's a particular type of individual, and this comes in the course of conversation with the client, it's a particular individual for whatever reason, they're going to see their day in court. Once you as an HR professional know that they're going to see their day in court, it would behoove you not to put this person in touch with an employment lawyer, because that employment lawyer is going to be the one representing them in court. They need to know what's going on along the way. You can, of course, fill them in, but it's not the same as them actually representing them. So typically, 90% of the time, we're able to mitigate in its totality a termination for our clients. 5% of the time, we're able to get it there most of the way, but there are those 5% of the time where we say, hey, at this point, we are compelled to say that you need legal representation, and we'll work with them, to get them all the knowledge that they need to know from what we've already done. But yeah, if you ever have an HR person that says in every circumstance, we can do this, you never need to see an employment lawyer, then I would question the integrity of that HR person.
Well, we had a couple questions from listeners, Carolyne, which is great, from our previous one. And one of them was, we have a few employees who have received medical notes saying they must work from home. Are we required to allow for this situation to occur? And it's great. And we're seeing more hybrid work more than ever before. Something that, was kind of foreign to a lot of companies several years ago before the pandemic. Yeah, what would you recommend in that situation?
Yeah, it's ironic because we traced that question as one of our top 10 asked questions this in 2024 so far. So this is a real thing. This is what I'm glad someone asked it, because it's what other people are asking. Technically, no. Whether it be a doctor or another treating medical practitioner like an RN or what have you, they have the right to make recommendations. And if it's founded properly in the medical evidence, they have the right to provide some direction or suggestion to the employer. But at the end of the day, it's super important for employers to recognize the doctor is not the employer. You are the employer. You make that decision, and you use the medical from the professional to help you make that decision. Simply getting a medical note saying you are required, I think this person should work from home for the next 6 months or whatever like that, that's not appropriate nor satisfactory, as I said in the last podcast. You're entitled to restrictions, capabilities, and prognosis. When you get that functional abilities form, which we referenced in the last podcast as well, when you get that filled out and it has all those things, if there's no limitations or no lack of capabilities that suggests that they can't come into the workplace, then you can deny the request. You do not have to let that person work from home simply because a doctor said that you do. If the doctor wants to pay them, have at it. But if you're paying them, that's your decision. You'd be wise if the medical that you get back, there's sort of capabilities or restrictions that suggest that working from home for them is a requirement or needed, you'd be wise to follow that. But short of that, which is, by the way, about 9 out of every 10 cases that we face, we're telling the client, no, you don't need to accept that. They should be coming into work. There's nothing about their medical that suggests that they need to be working from home at all. And 8 of those, I'd say 8 to 9 of those 10 cases, they come back to work with every instant, and the other 1 or 2, the employee usually quits.
So, Rob, there was another related question to our prior episode that we did together, and very interesting, when you talk about modifying a contract. So we've been talking a lot about pharmacare and high-cost drugs, and, some employers are looking at some tough decisions around their benefit plan. If someone's off work and that person happens to be on a high-cost drug, let's say $50,000, $100,000, what are the options can that employer continue to make modifications to their drug plan?
So as an example, like they want to put in, say, just from a financial, to try to control their own financial costs, like a $5,000 drug maximum per person per year is an example, which know that, maybe they don't know is that employee in particular necessarily that's on the drug. They know somebody's on it, could be a spouse, could be a child, but they know that somebody's going to get impacted. Do they have the right to do that? First, I haven't heard that question in years since pre-COVID, because this used to be a question we get relative. Priorities have changed about benefit plans since COVID. So it's been a while, but it's a great question. And it's not an easy answer, and there's no specific answer I can necessarily give. I could give you the reasons why, though. So typically, obviously companies or employers are not allowed to know who's on what, right? Correct.
They can do it in classes. Like they could say, okay, all of our non-managers, this is what they're doing for benefits and how much it costs and that types of things. With designer drugs, it's more common than not, especially if you're not a large business, that the employer knows the person or people that are on the drug.
Or they suspect.
Or they suspect, yeah. And it's nothing to do with disclosure, anything they've done wrong. It's just typically there's other things that come with that drug that lead them to suspect or know that this person are on the drug. So by doing that, they're in fact targeting specific individuals that they should know or suspect are actually in need of this, and it will cost them a lot of money. So no different than the termination thing, like when we talked about with the extension of, I think it was terminating benefits when someone's on a medical leave. You're wise to provide a working notice of that change. This would be a meaningful change for that person. If they had a $50,000 designer drug and you caught it at $5,000, that's a $45,000 hit. That would be a meaningful change. So for me, that would paramount to potentially construct a dismissal if the person made the claim, which is the same as termination. So I would advise a client in a circumstance like that, if you want to make that change, you need to provide a few years notice to all employees, not just those 2, even if you know who they are.
Few years notice.
I would suggest in a case like that, because that's a big change. Now, when I say a few years, that's if it's a longer term employee. That's if they're a senior employee. If you're a shorter term employee and you're younger in years, maybe not an executive or a managerial position, it doesn't need to be 2 years. It could be 6 months. But keep it in mind, you're not supposed to know.
So you're saying if it's specific, if they think it's a smaller organization, high probability we guess it could be this individual. But if it's a larger organization, mid-sized company or larger, you don't know. Right? You don't know who it is. You're just looking at we might have 8 or 9 significant stop loss claims, and we're just we maybe want to redistribute that potential savings into other benefits. I'm just using that as an example because that's common that we're seeing more than ever before. So even in that scenario, you're still looking at a very long duration of change. I know every situation is different. Don't get me wrong. I'm not, it's not black, white, but
it's definitely less liability because it's harder to suspect who those people are that might be on those drugs.
Yeah.
So you can't say that you're specifically pointing out those people. And again, it's a group benefit plan. You're doing it for everyone. I still always recommend notice of a change of benefits in any circumstance, as much notice as you can provide. And that will mitigate your liability, even if that person does claim constructive dismissal and say they were entitled to a year's pay. But you provided 6 months notice of the change in benefits. Because you provided the 6 months notice, that would go against, in most cases, the reward of 1 year. So you mitigated your damages by 6 months. So any notice you can provide is going to mitigate your liability in a case like that.
Makes sense. And in that scenario, I mean, there's lots of reasons not to go around the path of putting in a drug cap that are a whole other episode. But in the instance that someone is doing this, it's great to know the right way to mitigate that risk. So I think that brings us to the close of this episode. I think some of the biggest learnings I've had is, before you do anything, check with HR, consult legal, check with your benefits advisor, check with the carrier, get it properly in writing with notice, and that will help mitigate your risk. So any final comments, Darcy or Rob?
It's been a great pleasure to come back for a second time. I'm honored that I was able to be invited back. I really appreciate the relationship that HR Covered and the Benefits Alliance has, and I love working with you both.
Well, we appreciate you've been really beneficial, your organization, to our benefit advisors, and collectively, we have 13,000 clients coast to coast, and there's consistent HR issues, probably more than ever before, as things continue to evolve in the workspace. So really appreciate your support, and thanks for being here today.
My pleasure.
Thanks again for listening to the Benefits Alliance Voice. If you feel this could benefit someone please feel free to share our podcast and subscribe wherever you get your podcasts.